Let me put before you today section 184 of MV Act. This speaks on driving dangerously so as to cause danger to the public in general. So driving dangerously, driving recklessly, it is charged under section 184 of MV Act. However, there is a large scale criticism in reference to this specific law. Let us discuss what is that criticism is. First, what does the Act say? Act says that anyone driving dangerously, they will be fined for the first offence either 6 months of imprisonment or 1,000 rupees fine, and for the subsequent second and third offences of the similar nature under 184, so they will be, the imprisonment can be up to 2 years and fine. It will also lead to the suspension of the driving license of the driver in question. But now, what does this Act say? It says what is the determinants? What are the parameters to say that this offence is actually done by a particular driver, particular person? It says there is no speed, there is no specific speed, 60, 70, 80, 40, there is no determinant as such. It says in a circumstance, in a situation, even a person is driving under 10, 20 kilometers can also be charged under this section. It says he was driving in a dangerous way in that circumstances, in that situation. So therefore, even a person who is driving normally in a normal speed can be charged. So this gives the executive, the police, an opportunity to challan the drivers, the vehicle owners, unnecessarily. In order to challan, in order to achieve their targets of collection of fine, they can charge anybody. Therefore, there is a high rise of criticism for this section. So it is determined, the offence is determined prima facie by first hand by the police. So they say he was driving dangerously. If it is even 20 kilometers, he can always say in this situation, in these circumstances, he was driving dangerously, which was against the public. It was dangerous to the general public. Therefore, he is challenged. But the criticism is it is a large scale misuse by the police. So according to me, such law, though it is welcome in order to safeguard the people, in order to have control mechanism of drivers, the determinants are very weak. So if the police decide that he was driving in a speed, in a manner that endangers the life of people, this is rubbish, because until unless this is videographed, it is supported by a videograph that which is taken by the police themselves. They must videograph and prove that yes, this person who was driving at 10 or 20 or 30 or whatsoever kilometers in that circumstances was driving dangerously. For example, there is a school, education institution where kids are crossing. In that way, driving at 10 kilometers will also be dangerous. But what is the determinant? I have got certain complaints from my clients, from the public, that this act is being misused. Though it can be challenged in the court, who has got the time? Which person has got time to challenge 1,000 rupees, 2,000 rupees? Or he has to lose his license is suspended. Who has got the time? Unnecessarily multiplication of cases in the court. So therefore, no law should be made in such a way that it cannot be determined, the assessment of the offence, until unless it is properly determined that law is bad. And generally there is an outrage by the public, there is a dissent by the public. Therefore, it is suggested that the police, the executive, when they find under the section 184, must possess the videographic proof. Otherwise, the general opinion of the people is that this law is misused in a large scale by the executive in order to achieve their targets. They have been given targets to fine so and so in a number of cases and achieve so and so revenue for the government. They just keep challenging the people under this section 184. This trend is dangerous. So any law that has no proper determinants, that cannot be properly assessed, is bad law. So let the authorities take note.